from the lectern so that you can hear what he says. And I think what Riz will set the scene on all three so you can get the overall plan, but then we'll focus on these various topics.
Great, thank you. Louise, you'll give me a 5-minute warning when I'm 5 minutes from the end. So if I'm too far behind, I'll speed up and only focus on things which I need to focus on. So it's a real pleasure to be able to speak to you this morning about something which sends most people to sleep, the definition of insolvency proceedings. Many of my US colleagues are firmly of the view that this doesn't matter. It's merely a semantic issue, and it's not worth debating about. But actually, as I'm sure everybody in the room and most of those dialing in are familiar, it makes potentially a huge difference whether a proceeding can be characterized for the purposes of the CTC as an insolvency proceeding. And I want to set out the reasons why that matters and what those reasons tell us about how we should go about interpreting this notion of insolvency proceedings in the CTC context as such. So I'm going to talk about these three topics: interpretive approach, insolvency proceedings, and then insolvency, intriguingly set out, I hope, separately from insolvency proceedings. So let's start with the interpretive approach. We know that the CTC tells you how to interpret it. It has something to say about its own interpretation, as most treaties do. And I want you to bear this in mind as I take you through the main points. I want you to bear in mind the value of any judicial dicta flowing from a hearing in which the court is not referred at all in writing or orally to any of the CTC's own rules as to how it ought to be interpreted. And you'll see why that is a shocking omission, which in my view significantly undermines whatever value might otherwise be associated with such dicta. So note, first of all, 5.1, note the three elements. It refers to the need to have regard to the CTC's purposes, to its international character, and to the need to promote uniformity and predictability in its application. Now, most of you would see that these are the standard principles of treaty interpretation. However, as the official commentary points out, there is one difference. Treaties refer to good faith, the interpretation being done in good faith. That's been taken out. And instead, you find a reference to predictability because it was thought that good faith was unacceptably uncertain in the sorts of high-value cross-border transactions with which the CTC would be concerned. Now, the CTC deploys concepts which, and this is tiresomely familiar, but nevertheless significant beyond compare, it requires an autonomous meaning to be given to the concepts that it deploys insofar as practicable. The official commentary tells us that Article 5.1 is an instruction to national courts to avoid national concepts. This warning not to be parochial is profoundly important. And I'm sorry to say that the debate in England in particular has been deformed by parochiality, by the disregard for this importance of autonomous concepts. I'll come back to this, as you will see. Turn to Article 5.2, and this also underlines the importance of autonomous interpretation. The commentary says that Article 5.2 requires a cascade approach. And you see the cascade first in the reference to issues which have been expressly settled. And this means that you read the text, giving it its natural and ordinary meaning. So that's at the top of the cascade. And then further down, any gaps which are left after you have read the text, giving it its natural and ordinary meaning, are to be filled in accordance with the general principles on which the CTC is based. And only then, after you've run out of purposes, after you've run out of the natural ordinary meaning of the text, after you've run out of the principles, the general principles on which the CTC is based, only then at the bottom of the cascade, you get to any notion of national law, of domestic law. So bear in mind how much weight to attach to any judicial dicta would start not from the first level, not from the second, not from the third, but start at the bottom by going straight into the most parochial concepts of national law. How much weight to attach, I will come back to that. Okay, so purposes. So we go to the preamble for the purposes, as you know, towards the top of this cascade of interpretive guidance. Here's what the preamble says, and I'll just put my own words to each of the points in the preamble as you read through them. First, the CTC says that it responds to the need for efficient financing of high-value mobile equipment. Second, it does so by facilitating asset-based and lease finance arrangements. Third, the CTC performs this facilitative role by ensuring that interests in such equipment are universally protected. I'll come back to that. Fourth, such protection is of mutual benefit for all stakeholders. Fifth, such protection should promote party autonomy, profoundly important in the scheme context. I'll come back to that. Sixth, such protection would include the creation of a legal framework and an international registry. Now, cumulatively, the overriding purpose, I think, of the CTC as derived from all of these preambular comments is that when you read the CTC together with the aircraft protocol, the purpose is to produce economic benefit by increasing the availability and reducing the cost of finance. And this benefit occurs when lenders to be make lending and pricing decisions, whether to lend and if so, at what cost, in anticipation that their interests would be protected in all states of the world after lending, all states of the world. That's what it means, in my view, to give protection to CTC interests, which is universal in this preambular comment, in this preambular guidance. And when we talk about protection in all states of the world, it should go without saying that in particular, protection is most needed in situations where the borrower is distressed, is insolvent, goodness me, may even be in insolvency proceedings as defined in the CTC. That's the most dramatic, the most dire set of circumstances that, focusing on the lender's perspective, the lender is likely to face qua lender. And that is when the CTC's protection is most required. Go back to party autonomy. Party autonomy is to be promoted in the way that the CTC is to be interpreted. And I suggest to you that the relevance here is that in all states of the world, you promote party autonomy by holding all of the parties to the agreement to which they signed up and to protect CTC interests against non-consensual modifications. So if the CTC has promised you protection, has promised you a particular way of responding relevantly to the debtor's insolvency, then you promote party autonomy by holding the parties' feet to the fire and ensuring that that protection is available. If non-consensual modifications of CTC protected interests are possible, you are detracting from party autonomy. So again, a fortiori when the debtor is in insolvency proceedings. Okay, purposes. Article 11 of the aircraft protocol, official commentary points out that the empirical work and the econometric work which was undertaken in advance of the drafting was unequivocal that this was the most important enforcement provision and the most significant in achieving the economic benefits that the CTC framework is intended to achieve. And two of the elements of evidence, I mean, this is not a theoretical point. You don't need to undertake economic analysis. This is just part and parcel of how the market operates in the context of aircraft equipment. And the two elements that many of you would know, but this is the Cape Town discount, which arises under the OECD's arrangement on officially supported credits. This has an aircraft sector understanding, which includes the Cape Town discount, of up to 10% of the minimum premium rate granted by government export credit agencies. And this discount is only granted to states who meet certain criteria, one of which is that they have made a declaration in favor of alternative A of Article 11. Now, that 10% is not an abstract theoretical surmise. It's just what happens. And it happens in significant part, if and to the extent that the state has signed up to alternative A. Similarly, the enhanced equipment trust certificates are a means of raising finance from the international capital markets in order to lease aircraft. The ratings take account of the benefit of certainty of enforcement brought about by the CTC and permit airlines in contracting states that have made the relevant declarations to obtain enhanced credit ratings. Now, keep that in mind and think about the possibility of aircraft creditors, that is, those whose interests are supposed to be protected by virtue of the CTC, being unable to access that protection, benefit from that protection at the time when it was most needed. That is, when the debtor was distressed, insolvent, even in insolvency proceedings. In those circumstances, the entire framework of the CTC would be dramatically undermined. And you would get to a state where contracting states would not be able to signal to credit markets the credibility with which they would protect the rights of lenders to be in the worst case scenario, in the scenario where the borrower after borrowing became distressed. And so the whole edifice of the CTC would be undermined. The whole edifice turns on ex ante certainty, the certainty before and at the point at which the lending and pricing decision is made. So don't look at it from the point of view of the aircraft, an airline already, a borrower already having become distressed. That's a hemionopic perspective. That is covering one eye and only looking at half of your field of vision. Instead, you need to take a step back, open both eyes, and look from the entire life cycle of credit from before the lending decision being made to the point at which it needs to be enforced. So, quick conclusion on interpretive approach: autonomous interpretation, avoid parochial concepts and interpretations, preserve intended benefit of the CTC, particularly when needed most. This argues in favor of the widest interpretation of insolvency proceedings, promote party autonomy, so ensure that CTC protected interests cannot be non-consensually modified, and international character, uniformity, and predictability. When a court in one state, one CTC state makes a decision, that has to be given due consideration by courts in other states. We now have the first and so far only fully reasoned decision from a CTC state in AirAsia. This is Judicial Commissioner Ong Chi Kwan's judgment in AirAsia X. Proper adversarial hearing, arguments, expert opinions, including Jenny Payne on one side and Louisa's and my opinion on the other, fully taken into account to the extent permitted in the circumstances of the hearing. And then you have a decision about the scheme in appropriate circumstances being a CTC insolvency proceeding. That has to be contrasted, I'm afraid, with the MAB decision, where we have two of our undoubtedly most brilliant judges, Ms. Justice Zaccaroli at the convening stage, Ms. Justice Snowden at the sanction stage. They are not referred to the interpretive criteria for interpreting the CTC at all. I understand that at the sanction hearing, Ms. Justice Snowden said half sarcastically, so I suppose I'll now have to sit through a lecture on autonomous interpretation. And the response should have been, my lord, I'm sorry, but yes, you do, because that's really important in setting the scene. That's how the treaty requires itself to be interpreted. That's what the state has signed up to. So boring though it might be, yes, we do have to go through that. No, nothing of that sort. And then the little paragraph in Ms. Justice Zaccaroli's judgment where she says, I'm not going to make a decision, I don't have to. This decision may never have to be made. He was right, it didn't have to be made. But the one side that I've heard, not adversarial, the one side I've heard puts out a strong case that the scheme is not a CTC proceeding. And then Ms. Justice Snowden doesn't even say anything about this in the judgment, but apparently some comments that he made in the hearing are given wide publicity in a way which I find particularly shocking and irresponsible for a variety of perspectives, not least because it's just not fair to this brilliant judge to publicize and ventilate comments which he's made without making a decision, without having to confront adversarial arguments. So, need to promote uniformity, international character. We have to look at AirAsia X. Look at MAB in light of the considerations I have set out. Other sets of considerations, how not to interpret. I mentioned to you that I'd come back to the parochiality point. One of the problems with the English debate has been that it's just been obsessed in the most harmful way, harmful to efficacious interpretation, by the division in the EU instruments. On the one side, the insolvency reg, on the other side, the judgments reg and the Lugano Convention. Now, the problem is twofold. I mean, there are many problems, but the primary problems are, first of all, the purposes for which you have to decide whether something is an insolvency proceeding for the Lugano/judgments reg versus insolvency reg debate. They're completely different to the purposes for which you have to identify insolvency proceedings for CTC purposes. For Lugano and the other, insolvency reg dispute, the reason why you have to identify what falls in the bankruptcy exclusion to the main instruments, which are the judgments reg and Lugano, is you have to identify those exceptional circumstances, those exceptional types of proceedings where a bilateral allocation of jurisdiction, creditor to debtor, bilateral, is not going to be appropriate. And you need to identify those instances where, because of the peculiarities of the nature of insolvency proceedings, jurisdiction has to be allocated collectively, not bilaterally, possibly on the basis of COMI, possibly on the basis of establishment, possibly even on the basis of the presence of assets as such. But there are exceptional things going on which require derogation from the general rule that jurisdiction is allocated bilaterally. And so in that context, you have to give a narrow interpretation to what constitutes an insolvency proceeding. That's well established in the jurisprudence. As I said to you, that's completely 180 degrees inconsistent with the CTC, where you have to give the widest possible interpretation to ensure that in all possible states of the world, creditors are given and ensured the protection to which they and the borrowers signed up at the point at which the lending and pricing decision was made. So completely misleading to draw on this particular aspect of the English debate and possibly slightly broader European debate, but mostly it's been English, to try to score points about the CTC. And then you have the 5 minutes. So then you have the dovetailing principle, which is about the requirement that if something doesn't fall into the insolvency regulation, then it must fall into the judgments regulation, and it's not an insolvency proceeding. Now, the problem, amongst other things, I mean, the dovetailing principle is much misunderstood, as Ms. Justice Zaccaroli pointed out in Gate Group, but put that on one side, the main problem there is that the state, EU member states have a choice whether to subject an insolvency proceeding to the insolvency reg. They can choose whether to have that proceeding listed in the annex to the insolvency reg. If they don't have that proceeding listed in the insolvency reg, schemes of arrangement were never listed in the insolvency reg, in the annex to the insolvency reg, it means that the better argument is they're not covered, regardless of their intrinsic nature, regardless of whether they meet the substantive requirements for something being an insolvency proceeding, even for that purpose, let alone for CTC purposes. And then you have pressure by this misunderstood version of the dovetailing principle to say, well, since it's not in the annex, it's not an insolvency proceeding, therefore it must be a non-insolvency proceeding. Well, that is problematic even in the insolvency reg versus judgments reg context for a variety of reasons. It's completely, hopelessly misleading in the context of CTC. So there's an asymmetric relation, I suggest to you, in view of those points. Everything which falls in the bankruptcy exclusion to Lugano, everything which gets covered by the insolvency reg is going to be an insolvency proceeding for CTC purposes. But the converse is not true. It may be that for a variety of reasons, which Louise and I have spelled out, some types of proceeding don't get covered. For one thing, the proceeding meets the substantive requirements, but as the member state doesn't have it listed in the annex. That's not a basis for saying that it's not a CTC, insolvency proceeding. Okay, I'm just going to take 3 minutes then to talk about these remaining elements. Law relating to insolvency, you're all familiar with the defining characteristics of insolvency proceedings as defined in the CTC. There are 4 elements. We can take it as read that schemes are judicial proceedings and therefore the purpose of reorganization or for a value-preserving liquidation. There is no requirement as to the law, the relevant proceeding being a proceeding under a law relating to insolvency. As Louise and I point out, this was explicitly removed from the text during the drafting process, so that's not a requirement. So the possible questions concern whether schemes are collective proceedings and whether they are proceedings in which the debtor's assets and affairs are subject to the court's supervision or control. Quick points about collectivity and court supervision or control. No specification in either the commentary or the text of the CTC itself about collectivity. Collectivity in what sense? The proceeding should cover all of the debtor's assets or most of its assets, all of its liabilities or most, the claims of all of its creditors or most of its creditors or some of its creditors. Should there be a moratorium? If there is a moratorium, should it be on some or all claim enforcements by the debtor or by the creditors or by some creditors? The nature of the moratorium differs depending on proceedings. We are familiar with that in England. The administration moratorium is different from the winding up moratorium. So there is no sort of one platonic moratorium which has to be present before you can think that there is a moratorium as a defining characteristic of the proceeding. CTC says nothing about the nature of collectivity. All it says is collective proceedings, those for the benefit of creditors generally. Okay, so it may be that creditors generally benefit by having a restructured and still trading debtor if 90% of the creditor's debts get restructured in some cases. But it may be that on the facts of another case, you only need to restructure 60% of the debts and you still generate the same benefit. 60% of the debt is coming due at a point where the debtor faces difficulty. And that's what you need to restructure in order to give the debtor the chance to trade out of its difficulties. Well, that would meet the definition. Or why does it have to be 60%? How about 51%? Same principle applies. Well, if 51% is fine, what about 49%? What about 20%? What about 5%? 5% of the debt is going to need restructuring or the debtor collapses. But if you restructure that 5% of the debt, the debtor can trade out of its difficulties. So on that basis, given that there is nothing else in the text or the commentary, I suggest to you the notion of collectivity has to be interpreted purposively, functionally, whatever is necessary and sufficient to give the restructuring proceeding its efficacy. Same point applies in relation to court control or supervision. Nothing about the nature, extent, or form or timing of court control of assets and affairs. Absolutely clear the debtor in possession is covered. Debtor in possession proceedings are covered where the debtor's pre-distress management retains control of the assets and affairs, and the court has whatever level of control and supervision is necessary to give efficacy to the proceedings. So no doubt the debtor in possession proceedings are covered, and this is a point that Ms. Justice Zaccaroli made in Gate Group in a different context. So I put it to you that you take a functional approach and you basically say, is the level of court supervision or control of the debtor's assets and affairs such as to render a restructuring proceeding efficacious? If the answer is yes, that satisfies the requirement of court control or supervision. I'll stop there. I may come back to the insolvency element because we decided that we would.
Yes. Okay. Yes. Well, what would. So what we're going to do now is take some of these points, and we have various members of the panel who are going to comment on them. So the interpretation point, first of all, which Riz talked about at first, we're going to have an academic view, an academic and economic view, I think, from Felix, and then some thoughts from Ken. And then we'll start thinking about the insolvency element of the definition. You might want to say one or two words about that before Felix and Philip kick me on that one. Okay, so Felix, over to you on interpretation.
Thank you, Louise and Riz, for this excellent introduction and overview. I've been asked to give an economic perspective on the interpretation of this, and I'd like to do so with the logic of my contribution is that I first ask why we need this word in the first place. That concerns the question of state failure or market failure. Then I'll talk about the costs and problems that state and market failure causes in this context. I'll ask the question whether law and institutions are good solutions to this problem. And I'll conclude by then drawing from these insights on what they tell us about the interpretation of the CDC. So that's the logic of my conclusion. The first question is, why do we need international insolvency and debt finance law? Rules such as cross-border context. This is state failure as opposed to market failure. Answer B, it's not state failure, it is rather that citizens in different countries have different interests, state react to that, and therefore have enacted different insolvency rules. In that sense, it's not state failure, but just states react to different justice interests. Answer C, because of national sovereignty, if you are in the cross-border context, you've got enforcement problems if you're cross-border, and that is why you need these international rules. I would again classify this as state failure. So what is it? In my opinion, we are looking at state failure. It's rather questions A and C rather than B. Remember, answer B was that actually there are different justice interests in different countries and states react to those. I do think while such interests in terms of what citizens want from insolvency law may differ, perhaps in some states they want weaker creditor protections, in others they want stronger creditor protection. I think if you look overall, you can see that a lot of harmonization from a transnational perspective could be achieved if the political actors would be interested in doing so. To give you an example, a recent study by Reinhard Borg and Michael Wieder looking at avoidance transactions law in the European context, which is soon to be published, actually discovered that looking at avoidance transaction law in the European Union, there's a lot of doctrinal difference, but there's not that much difference in terms of results. So actually one could harmonize a lot if one wanted to. Now, why does it not happen? I think that that is an issue of doctrinal path dependency. So you've got the rules, changing them would create costs in terms of transitioning from one system to another system. And for politicians, that's not very attractive because these costs would occur in the short and medium term, but the benefits would arise in the long term. So why should you engage with that? That's why it's not happening, I think. However, transnational harmonization of insolvency law is not unheard of. For example, there are the Nordic-Baltic recommendations on insolvency law 2016, aiming to harmonize insolvency law in a substantive perspective. So my conclusion is we do need international insolvency law or international debt finance law, rules such as the CTC, because of state failure. But interestingly, states react to such state failure by using a second best solution, that is international insolvency law, rather than the first best solution, that would be to offer harmonized transnational insolvency law rules, unless citizens really prefer different outcomes, which I think they rarely do. Question 2, is it all state failure? No, I don't think so that it's all state failure. I also do think that market failure plays a role. However, in the international context, I think many of the issues are actually not specific to the international dimension. Conflicts of interest, coordination problems also concern merely domestic insolvencies. However, there are specific market failures in the international context, and these are distance, time difference, language, cultural differences, and also active form shopping by actors. So there are specific international market failures. Question 3, what are the problems or the costs caused by state failure and market failure in international insolvency? I think there, what I'm saying is very much aligned with what Riz has already spoken on. I do think that this causes ex-ante uncertainty. You don't know what you will get if the rules are different, and you do not know this while you decide on whether to give credit and at what terms. Also, once the problem arises, you've got higher costs to solve the problem. So you've got higher ex-post costs caused by coordination problems. Now, every ex-post problem is also an ex-ante problem, because you can anticipate that you'll have lower recovery rates, that you have higher costs of solving the problem once financial distress hits. You will price this into the credit, and you'll either not give credit or you'll give so at worse terms. What are the outcomes? Finance is more costly in a cross-border context as a result, and less projects and firms will be financed. And that is something that, if you look at it from a welfare perspective, is to be avoided. Question number 4, can law or institutions such as courts actually solve this? Interestingly, I do think that there's not much empirical research on this, even though it's a very fundamental argument for lawyers to enact such rules. And if I'm not mistaken, there is very little real empirical research on the international dimension of insolvency law. The existing research, for example, by the European Banking Authority, published in November 2020, shows that law and institutions actually do matter for recovery rates. And Riz, you've also mentioned 2 arguments: the OECD sector understanding on export credits for civil aircraft and the enhanced equipment trust certificates. And there, while this is not empirical research, we've got an empirical indication that it matters. Which brings me to the last question. I don't even need the full 2 minutes they've given me. Louis, I only need 1 more minute, because my last question, and the last question is, what follows from what I've said for the interpretation of international insolvency law, international debt finance laws, such as the CTC? Argument number 1, I think what I've said very much is a strong argument for autonomous interpretation, because if the problem is state failure in the form of differing insolvency laws, then actually it would defeat the very idea of solving that problem by further state action now to allow locally different interpretations. Number 2, if the problem is uncertainty and complexity, again, autonomous interpretation leads to reduction of complexity and to a reduction of ex-ante uncertainty. Again, if you would allow different local interpretations, you would reintroduce complexity and ex-ante uncertainty. So if autonomous interpretation in particular leads to a consistent interpretation, then there's a very strong argument, I think, from an economic perspective, that international insolvency law, debt finance law, should be interpreted in an autonomous way. And what also matters a lot is that you have your priorities clear, and you spoke on the cascade on that. And I think that's a further argument that follows from an economic view on this. So to conclude also, I think that's in line with what you said, Riz, is that I would say that ex-ante certainty trumps the ex-post specific case if there's a difference. Because of the relevance of uncertainty ex-ante on the cost of credit, I would say solving this is actually more important for our societies than if at all there is a difference to the ex-post solution. then you should prefer ex ante certainty. Again, an argument for an autonomous interpretation. And it's in my point of view, Riz, what you have explained is very much in line with what I would deduct from an economic point of view on this.
Thank you very much, Felix. And now we're going to have a quick comment from Ken on his view, so some thoughts on an autonomous interpretation.
Thank you, Louise. Thank you, Felix. I'm going to be very quick here. I just wanted to make one practical point, is that the need for autonomous interpretation in the convention is something that practicing lawyers have had to live with for quite a long time now. It is nothing new. And I wanted to give you one example of that, which relates to nothing to do with insolvency proceedings, but to do with assignments and novations. So we have a strange situation where if you have two identical documents purporting to transfer, let's say, a lease agreement from A to B, one governed by New York law and one governed by English law, but otherwise substantively identical, it may well be that a New York lawyer would treat that as an assignment, but an English lawyer would treat that as an novation. So for a long time, we had a trouble as to what we did in practice with these documents. You know, did we register an assignment of an international interest? Did we register a new international interest? And you know, that was a lot of time wasted. It led to inefficiencies in practice, too many registrations, and so on and so on. Fortunately, in the last edition of the official commentary, it was cleared up so that now we have clear guidance in the OC as to what constitutes an novation using the autonomous rules of Cape Town and what constitutes an assignment using the autonomous rules of Cape Town. So if you have a New York law assignment, which by a New York law would be treated as an assignment, but under the autonomous Cape Town rules is a novation, we now register a new international interest because it is treated as a novation. How it is treated by its applicable law is not relevant. Okay, I just give that as one example of where we are already consistently applying the autonomous rules of interpretation of Cape Town. And exactly the same should apply to insolvency proceedings. For the sake of consistency, as Riz and Felix have said, and to promote the purposes of Cape Town, whether or not something is properly treated as an insolvency proceeding under English law or Malaysian law or Irish law or New York law is neither here nor there. The question is how are these proceedings treated under the Cape Town rules? And I think that is what we have to try to achieve agreement on in the coming weeks, the coming minutes, in fact.
Thank you very much, Ken. Okay, so we've had a long, an interesting discussion on interpretation. We're now going to turn to the question of the, Liz, if you want to keep going, the insolvency element in the definition of insolvency proceedings. And if I could ask Liz to be very brief so that everybody else gets a chance to speak before we open the floor. Thank you.
So I'm going to quickly take, as soon as my slides are up, so you have a visual cue there as well. So let's see if we can get to the insolvency. So we know that schemes are not insolvency proceedings under domestic law, but that's neither here nor there. You already have the point that there should not be a defeat of CTC rights. We need to talk about the interpretation for the purpose of the CTC, and there what matters is the insolvency-related event. That's what you need to interpret. Is the start of the scheme process in relation to this particular debtor, is that an insolvency-related event? The CTC talks about the commencement of the insolvency proceeding. It's that particular insolvency proceeding which has been commenced and which now falls to be assessed, which has to be assessed. It's not an assessment of the abstract nature considered irrespective of the context of the proceeding on the statute books. Well, second point, some proceedings are undoubtedly insolvency proceedings when applied to insolvent debtors and undoubtedly not insolvency proceedings when applied to solvent debtors. The winding up regime in the UK is an example. The same provision 122 of the Insolvency Act can be applied by virtue of the resolution of the member of the company, and that would be a solvent winding up. It would be not an insolvency proceeding. But under 1221A and F, so the same section of the Insolvency Act, you might have an insolvency ground as the basis of the commencement of the insolvency proceeding. So as far as the technical criteria in domestic law for commencement are concerned, it's the same process It's characterized in the same way, it's collective in the same way, and so on. But it can be begun one way on the basis of insolvency or another way on the basis of a resolution. So that doesn't determine it. Schlosser said in this debate decades ago that in order to classify the winding up in the UK and indeed Ireland for the purposes of that debate, the EU instruments debate, you couldn't make a judgment in the abstract about the nature of winding up. You had to look at the particular winding up. And I put it to you that that exactly is the approach to be applied in relation to schemes as well. Final point, I would say, and proceeding may undoubtedly be an insolvency proceeding, even if it may be commenced without demonstrating anything like the debtor's insolvency. Administration started by the qualified floating charge holder out of court. No need to demonstrate insolvency, but once commenced, the proceeding is the same as if it were commenced on the basis of insolvency in court through any other mechanism. CVA, no need to demonstrate insolvency. Are we going to say the CVA is not an insolvency proceeding? Even if you think CVA has an ambiguous status, the paradigmatic insolvency proceedings on the world stage are the US Bankruptcy Code chapters 7 and 11. No need to demonstrate insolvency to commence them. So it cannot be a requirement for something to be an insolvency proceeding that you have to demonstrate the debtor's insolvency in order to commence those proceedings. In Agricor, His Honor Judge Paul Matthews said that one of the grounds on which the proceeding can be commenced must be insolvency for that proceeding to qualify for model law purposes. No disrespect to the judge, he was presumably going on what he was advised, but that rules out for model law purposes chapters 7 and 11 of the US Bankruptcy Code. So it cannot be right. That dicta simply cannot be right. So what are you left with? In insolvency setting, we've set out 4 clear criteria, Louise and I. If the debtor meets those criteria, any of those criteria, then the scheme of arrangement in relation to that debtor assessed substantively as the insolvency-related event that it is an insolvency proceeding for the purpose of the CTC. And it doesn't matter that in other cases, it would be difficult to decide whether the debtor is insolvent. That the existence of difficult cases does not negate the reality of the easy ones. I'll leave it at that.
Thank you. Perhaps we could keep that slide up for the rest of this discussion, because I think it's quite important. Okay, Felix is going to give us an academic view, and then we're going to hear from Philip and Ken. So Felix first. Sorry, well, unless you want to go first, Philip. It's only the order I've got written down here.
Thank you, Louise and Philip. So again, economic perspective on this. It's not a legal perspective, because that's something to keep in mind. Otherwise, you will think that what I say does not make any sense. First of all, I think, from an economic perspective, terminology doesn't matter, and whether a rule is formally in an insolvency law or in a company law does not matter at all. Good example is the German legislature, which has shifted rules concerning insolvency between company law and insolvency in recent years, quite arbitrarily, but there was, of course, a reason. What matters instead is what insolvency proceedings do. And here is what I would think they do. They reduce the cost of financial distress where there is a higher number of actors affected. What is financial distress? Economically, it's either illiquidity, economic balance sheet insolvency, or a breach of a finance contract that is not cured. All 3 tests are actually the result of a market decision. Illiquidity is the result of a market decision because, for example, the debtor could not get more liquidity out of the market. It is interesting that the economic definitions of insolvency actually are applicable before or apply before the legal definitions of insolvency apply. For example, for legal cash flow insolvency, you need a certain degree of illiquidity, whereas illiquidity in an economic perspective hits right away once you've got a little part of a little degree of illiquidity. That may be the fact, or that may be the reason why future legal insolvency is relevant in some legal systems, essentially to make up for the later applicability of the legal insolvency grounds. What about collectivity? I said that, in my opinion, a higher number of actors needs to be affected. from an economic perspective to have an insolvency proceeding, because if there would only be two people affected, the debtor and the creditor, all you would need to do is hand over decision rights to the creditor, and that would be your solution. However, collectivity, I think from an economic perspective, obviously does not need to affect all creditors. There's no need that all creditors are affected. And Riz, you have mentioned this, and it was also mentioned correctly in AirAsia. Now, court control. Is court control concerning the proceedings or even the assets necessary from an economic perspective? I think not at all. Whether a court solves an insolvency problem or someone else does is a question of efficiency. It is, in my opinion, irrelevant from an economic perspective. And a good example is dispute resolution. Does a dispute need to be solved by a court? No, not necessarily. It can be solved in mediation or in an ombud procedure where there's no court present at all. Again, to emphasize, I'm speaking economically, conceptually. Obviously, I'm not speaking in terms of legal terminology. What I do think is that in the CTC, the court control element actually reacts to a tradition of legislators requiring court control of insolvency proceedings. But I think that tradition will fade. I think in the future we'll see less court involvements in insolvency proceedings. So I'm coming to my last point already. What I think, and I agree, is that the CTC aims to protect secure creditors against negative effects of insolvency proceedings. And then from an economic perspective, what kind of English schemes should be covered? Obviously, those where there is a legal insolvency ground, but also those where there's an economic insolvency ground. Illiquidity, economic cash flow, economic balance sheet insolvency, or a breach of a finance contract that is not cured. Schemes are always collective. So that is a given in that sense. And so I think that result then is in line with what the CTC's purpose is, because it would not be desirable to essentially have the economic effects of an insolvency proceeding, but just because it's, in terms of doctrine, not an insolvency proceeding, subject the creditor to those effects. I think, again, I'm in line with what you said, Riz. I'd like to end here.
Thank you very much, Felix. Thank you for the time. Okay, Philip, now it's over to you, but you'll need the mic. Thank you.
Can you hear me? Thanks very much. You can probably tell from where I'm sitting on the podium what I'm going to say or not say. Look, coming from a practitioner's point of view, and having obviously worked with schemes and now with restructuring plans for many years, I look at this from completely the other way and from completely the other end of the telescope. Looking first at the policy and economics and just answering some of these points. Schemes for many years have been used in every situation: reorganisations, takeovers, solvent situations, amends and extends, and yes, of course, in insolvency and distress situations. But there's a very, very wide spectrum, and they're part of the rescue culture, certainly in the UK. And they will apply to all types of sectors, regulated and non-regulated. But and therefore, I just looking at what Riz's points around kind of purpose and functionality. If schemes can't be used to turn around companies and to rescue companies, then I think that could be a problem. I mean, that could be a problem not only for the airlines themselves, but actually for the lessors. Some of the lessors will be kind of vociferously against these type of processes on the one hand. On the other hand, they may find themselves in a situation where they actually themselves need a scheme. So you have to be a little bit careful what you wish for. From a legal perspective, I mean, are these really insolvency processes? And I'm purposely being a little bit provocative here. And funnily enough, when I asked the lady outside, could she order me a cab? She said, "What, right now?" So, so there's one outside. Then, so I mean, schemes don't have any moratorium. There are, schemes cannot be imposed upon creditors unless they vote for them, 75% in value, majority in number. There are safeguards in terms of fairness. And just to put it out there, it's not possible, and I'm sure you all know this, it's not possible for an English scheme to forcibly reject leases and property type interests. So it's not like a PKPU in Indonesia or Chapter 11. So they're very, very different. Any attempt really to limit schemes and say, well, schemes can only be applied in distress situations. I mean, that argument has been fought and lost in the Scottish Line back in 2009 for an insurance company. The Goodrich, who were opposing the solvent scheme in the insurance context, said, you can't impose a scheme on us in this solvent context because they only apply in distress situations. And the Court of Appeal there, the inner house of the Scottish Court said, no, I mean, it's a flexible tool. They can apply in all sorts of situations. And this goes to the point that people are making. They're saying we must have certainty. And I completely agree. But certainty requires us to be able to draw the line somewhere. And if you look at the four categories there, where do we draw the line? I can understand if someone said to me, look, a scheme that's promoted by an administrator or liquidator is an insolvency process. Absolutely. After that, who knows? What does financial distress mean? Liquidity. You look at the older cases, Colt Telecom, Eurocell, futurity of cash flow insolvency. I mean, it's very, very difficult to know exactly where you are on that spectrum. And if you want certainty, I mean, you just can't say, well, anywhere on that spectrum is fine, because that kills certainty in terms of this process. And I would say for airlines and for lessors and anyone wishing to restructure any type of entity within this space. In terms of collectivity, Riz talked about Snowden, and as he was then, Mr. Justice Snowden and Zaccaroli, focusing on collectivity. In fact, Snowden, during the Malaysia Air sanction hearing, cast doubt on Zaccaroli's comments in Gate Group when he said, I'm not sure that schemes are collective processes, or words to that effect. And this is to your point, Felix, schemes can apply to a small section or class of creditors. So, and I think that's what he was focusing on with the backdrop of this is a rescue process. And I'm going to try and the courts have traditionally bent over backwards to try and make them applicable, to try and save companies. I mean, schemes have rescued many hundreds of companies over the last 15, 20 years, and restructured many billions of dollars of debt. And the reason is because that is a jurisdiction which the judges in the UK, at least, jealously guard. I mean, you just have to see Voss in Nef Telecom. So, I mean, I would say that I would argue that yes, I can see that schemes can be insolvency processes if they're promoted by an insolvency practitioner. I think after that, I think it gets very, very uncertain. But then I would also say, what are we scared of? Because you can still have compliance schemes that are compliant with CTC, and I know that's going to be discussed later by my partner William Glaister. But I think in a sense, the thing that people are scared of is having their leases forcibly rejected. But the point is that following Debenhams and cases that like that, they can't be. So I would say that they shouldn't be looked at as insolvency processes. But even if they are, we shouldn't be too scared of them because of the safeguards that apply.
Thank you, Philip. Thank you very much indeed. We very much wanted a counterpoint of view, and I think that's been great.
Shall I leave the point
now? I was just about to make anyway, which is that I was very firm with my panel that they were not to tread on the toes of the double bill, which I will introduce later, of William Glaister and William Peels, who is going to talk particularly about Article 11, subsection 10. And for those of you who are perhaps not quite so familiar with the details of the aircraft protocol, if there's anyone here, you might be thinking, why do we care whether schemes are insolvency proceedings? And of course, the reason is that if they are insolvency proceedings, then Article 11, Alternative A, will apply. And one of the things that I think Ken is now going to talk about is why we would care whether Article Alternative A of Article 10 applies.
Yeah, sure. So, I mean, firstly, just to agree with Philip, that clearly you can have solvent schemes. No one is denying that. The question is, when do you have a solvent scheme and when do you have an insolvent scheme? And that is a question that, by having ratified the Cape Town Convention, it's a question we have to answer. And we have to answer it, as previously agreed, using the autonomous rules of Cape Town. Now, it matters briefly, because if Alternative A applies in the context of insolvency proceedings, then you have an inability to enforce your rights during a waiting period. You have a a mandated waiting period, and you have in Article 1110 a rule against involuntary cram down, which is really the point that I want to concentrate on here. And I think we need to look a little bit at, excuse me for talking about money in the context of an academic conference, but sometimes you have to do these things. Felix does it much better than I do. There's a key issue here with aircraft, which sets it apart from other sectors of the economy, which are aircraft are rapidly depreciating assets. Okay, they have a useful life of, let's say, depending on the model of aircraft, let's say 20 years for the sake of argument. So the value of an aircraft is a key issue for a creditor in the Cape Town context. So if you look at, for example, a finance lease or an operating lease, the correlation between the payment flows under the lease agreements and the predicted future value of the aircraft are key considerations for the creditors in both circumstances. Okay? That is different to insurance companies whose creditors might be people with long-term contingent claims against the insurance company. That is different for lessors of real property, which are not necessarily automatically depreciating assets. Aircraft are depreciating. So when you are entering into an operating lease or a finance lease, the projected future value of the aircraft compared to the rental income, the correlation of those two factors is, alongside the credit of your debtor, the key economic things you take into account. And the reasons for that are, in the context of finance leasing, is obviously the loan to value ratio. So you work out, the amount of the outstanding debt owing to you compared to the value of the aircraft over the term agreed. If the payment flows are altered by virtue of a scheme, then your loan to value ratios will equally alter. The quality of your security will deteriorate. And not only the quality of your security will deteriorate, but of course the regulatory cost of you of allocating capital to that particular financing will also increase. So your security goes down, the return to you goes down, your regulatory costs go up. Okay. In the context of an operating lease, the rental it's quite a simple bit of economics. The return on your investment is calculated by the cost of your asset, the tax situation, the rental income, and the future sale of the aircraft. If the rental profile is flattened out or postponed or given a haircut, okay, then that correlation is also going to be adversely affected. Okay, these are not considerations that apply to insurance companies or necessarily to lessors of real estate. Okay, the quality of aircraft as rapidly depreciating assets has already been recognized by the English courts in the context of relief from forfeiture in Celestial Airways and Paramount. I think Philip might have been involved in as well. He's been everywhere. So the question then arises, if this is not an insolvent proceeding, okay, why would a lessor ever agree to a restructuring? If the alternative was not that you're going to get your aircraft back and you're going to have to remarket it, if you can insist on your counterparty performing their obligations under the lease agreement, why would you ever agree to a scheme? Now, I'm not saying you never would. There may be reasons why you would. The difficulty we have in these quite complex calculations is you may have a number of lessors who agree to it because they think that their interests are not overall adversely affected, and some who don't agree to it. And Cape Town says quite clearly that in the context of insolvency proceedings, you can't impose a scheme involving a cram down on a dissenting creditor. Okay, so bearing in mind those complex financial situations, we've signed up to the convention, we have to live with it. If there is a minority group of lessors leasing aircraft to an airline who is saying, if you don't approve the scheme, we're going to go bust, which has been the case, has been admitted by all the debtors in the cases we've been talking about in their pleadings, I think. If we don't agree to the scheme, we're going to go bust, okay, then Cape Town requires you to protect the interests of those dissenting creditors. That's all I had to say there.
Okay, well, thank you very much, Ken. Now, I'm going to stop our speaker speaking for now, because I'm sure there are lots of people